Hello, and welcome to this presentation on the new pre-action process that landlords and letting agents will need to follow from the 24th of August 2020. This is a new process for landlords once the courts reopen following the suspension through COVID-19, and it will apply to claims that were made and suspended in court prior to the 3rd of August, and there'll be a slightly different process for court cases that are applied for after the 3rd of August, and I will identify these separately within the webinar. So first of all, I'm just going to look at quickly what the new rules are and what have been put in place. So this is a change to the civil procedure rules. Now, this is a set of procedures that are set out for Court of Appeal, High Court and County Courts to follow in non-criminal cases through England and Wales to ensure that everybody has followed the correct process in getting a claim to court. They apply to all cases since 1999 and largely replace the rules of the Supreme Court and the County Court rules. Commonly referred to as CPR, these rules govern how the court will deal with applications for possession and eviction, amongst other things, but obviously it's possession and eviction that we're talking about today. So what are the key regulations and the dates here? So as I said, it's the civil procedure rules. Now, this is now an amendment number 4. We've had 3 previous amendments, and it comes under the Coronavirus Act 2020, and its effect is Practice Direction 55C. Now, I'm also going to look a little bit about the amendment prior, which was amendment number 3, but we'll come to that later in the presentation. So these rules come into place on the 23rd of August 2020, which is obviously when the courts remove their suspension. And it has an end date, although it's temporary legislation, it does have an end date, March 2020, but there are provisions for a review of whether the regulations need to continue after that date. So what can happen is we can look at September, October, it will be reviewed, and maybe the government will decide the rules are no longer required, and everything will just go back to the normal state of civil procedure. So this affects all claims that were put into court before the 3rd of August. Claims after the 3rd of August will be dealt with slightly differently, and there's a key time and date of at 4 p.m. on the 29th of January 2021, which I'll come to in more detail shortly. So the one thing we need to remember is these temporary rules will not affect the court's ability to make a possession order under mandatory grounds. So if you've used a Section 21 notice, the judge has no choice but to provide a possession order based on the fact that the Section 21 has been served correctly and is valid. The same as if a Section 8 is used and it's grounds 1 to 8 that have been used, which are mandatory grounds, the judge has no choice but he must award the possession order to the landlord. But these can be extended under exceptional hardship for a maximum of 6 weeks. So, for example, I'm going to talk about later, there's normally a time limit between putting the application into court and when you get your hearing is normally about 8 weeks. That has been scrapped, and we're looking at sort of like no time limit there. So it just goes to show how backed up the courts are, but it does emphasise that Section 21 and Section 8 mandatory grounds cannot be affected with regards to these new procedures, but it will matter whether your case actually gets to court or not. So the key points: all possession hearings which were sent to court prior to the 27th of March have been stayed. Now, stayed means that you've served your notice, your Section 21 or your Section 8, they have expired, and then you've put the application into court to have a possession order. It's that application. So any hearing dates that were set prior to the 27th of March, they would have been stayed as well, and we'll come on to what you need to do later on with those. So there is now what's going to be called a reactivation notice that will need to be served. This will be served on the court and the tenant, and it will also require additional information from the landlord to state what COVID-19 has, how COVID-19 has affected the tenant and their dependents and their situation. So a landlord will need to explain if a tenant has been furloughed, been made redundant, gone on to universal credit, all of those things. I'll talk about the reactivation notice in more detail further along the slides, but this is just some key points for you. Parties with a hearing listed after the 23rd of August should take urgent action to ensure they don't lose these dates. Now, it's really, really important, although the courts will reopen on the 23rd of August, anything that is stayed will remain stayed if you do not serve your reactivation notice. So it's really important, if you know that you had a court date, that court date will not automatically be reset for you. You will have to serve the reactivation notice. Now, here is really, really important. If you fail to file and serve your reactivation notice in respect of a claim issued before the 3rd of August, by 4 p.m. on the 29th of January 2021, the claim will automatically be stayed. Now, that means it will basically be taken off the judge's desk, torn up and put in the bin. That's what it means in layman's terms. So you have to be really on the ball with this new piece of temporary legislation. You have to get your reactivation notice in the right amount of time, and you have to do it before 4 p.m. on the 29th of January. Otherwise, you will have to start the entire process again. Now, you won't have to reserve your notice, so you won't have to reserve your Section 21 or your Section 8, but you will have to put a new claim in, so that's another additional cost to the court. Okay, and then 12 months after that date, the claim will be struck out completely. Need to understand the time frame surrounding this. It cannot just be left expecting the courts to send you another date for another hearing or another possession order. So what is a claim? So we've already talked about claims and applications. So the claim is actually the application to the court for possession, not the notice you've served on the tenant. So there has been some conflicting information in the media that this requires you to serve a reactivation notice to the tenant to reactivate the notice. This is not the case. This is the actual application that you've completed, the form you've completed and sent into the court. It's that you need to reactivate. So it affects applications sent to the court prior to the 3rd of August when no possession order has already been made. So this is just your application. If you've already got a possession order, then you don't need to do anything. The courts will do that automatically. This is the section between putting your application in and actually getting your hearing for the possession order. The activation notice will be required. Claims will not automatically be processed by the court when they reopen on the 24th of August if they haven't been reactivated. Failure to submit a reactivation notice, as I've already said, will mean that the claim will eventually get to a point where it is just struck out by the court, thrown in a bin, never to be seen again. So what is the reactivation notice? Now, the key point here is to understand that it doesn't have to be in a prescribed form. So we're not looking at something like a Section 21 notice form 6A, where it has to be set out in a specific way with specific pieces of information. This can be something that you put together yourself, but it must have key points of information in it. So it must be sent to the defendant, which will be your tenant, and it must be sent to the court. Now, it also applies to accelerated possessions. We didn't think it was going to, but it is. So that means normally an accelerated possession would just zoom through court and you'd get your possession order. You will still need to serve a reactivation notice even on accelerated possession claims. It's not required where a possession order was previously granted. So if you got a possession order just before lockdown and then your case was stayed, you don't need a reactivation notice. Your reactivation must contain the following information. The request for the claim to be reactivated. Now, you need to let the court know what you want them to do with your claim. Now, if you haven't yet had a hearing listed, then you would ask them to list a hearing. If you had a hearing listed, but then lockdown happened, so your date was lost in limbo, then you need to ask the court to relist it. If you had your listing, but you were waiting for a hearing date, then you have to ask for it to be heard. Now, in some cases, I've got referred on here. Sometimes the cases are referred on for case management. Very, very unusual in eviction cases, but sometimes it can happen. So on your reactivation notice, it must say to the court, I would like to list it, relist it, have a hearing, or have it referred. You need to set out what knowledge you have of the coronavirus effect on your tenant and their dependents' situation. So that doesn't include appeals. So if this is an appeal against an eviction, then you don't need to put this information in. This is purely for just eviction possession claims. So what you'd need to put on there is something like, as I said before, whether the tenant has been furloughed, whether a tenant has been made redundant, whether they are self-employed, whether they've gone on to universal credit, how that has affected them, what you've done in the interim to try and support them. All that needs to go in the reactivation notice. Now, this is something you're going to provide to the tenant as well as the court. So you need to make sure the information is accurate. Now, if you've had no communication with your tenant and you genuinely don't know what their situation is, then that's all you can put in your reactivation notice is had no communication with the tenant, do not know their circumstances. The reactivation notice cannot have a right or a wrong answer because this is based on the experiences of two individuals. If you haven't had an experience, then there's nothing that you can put in the notice. So where a reactivation notice on the defendant and the tenant, especially in a case of rent arrears. So if you're using a Section 8 and you've served it on Ground 8, which is rent arrears, then you as the landlord must also provide a minimum of 2 years previous rent account. Now, again, this doesn't count if it's an appeal, but you've got to now, if you've had a tenant in that property for over 2 years and suddenly they've got rent arrears and you've gone under Section 8, Ground 8, you need to provide, or grounds 8, 10 and 11 to be precise, because you're using the discretionary grounds as well. But if you are claiming for rent arrears, you must provide a minimum of 2 years worth of rent accounts. Now, if your tenant's only been in the property for 6 months, then absolutely you can only provide 6 months worth of rent accounts. But if your tenant has been in the property longer than 2 years, then it is the full 2 years worth of accounts that also need to be provided with this reactivation notice. Where this information isn't provided, i.e. the information to tell the court what you want to do with the note, with your claim, as in list it, relist it, hearing, information about COVID's effect on your tenants, and rent arrears statements and previous rent statements. If you haven't provided that, the judge does have the ability to basically adjourn your proceedings and basically tell you to go back and start again. So it's really, really important to make sure that when you're doing the reactivation notice, you've ticked all the boxes with regards to what you need to have in there. And it also makes landlords a bit more mindful about keeping really accurate records of rent collection, because you've now got to prove this over the past term of the tenancy. If it's shorter than 2 years, or if it's 2 years or more, you've got to go back 2 years and prove the tenant's ability to pay. So now we're going to talk about claims after the 3rd of August. So if you're putting your claim in, your paper claim into the court after the 3rd of August, you won't need to use a reactivation notice. Your claim will be treated as normal. Landlords will need to bring to the hearing, once you have a hearing date set, 2 copies setting out what knowledge you have of the effect of COVID on the defendant. So again, you still need to have all of that information ready. You just don't need to serve on the court if you're serving your application to the court after the 3rd of August. Now, what you do need to do is, once you get your hearing date, is give the tenant, not less than 14 days before the hearing, the document that you have sent to the court explaining what knowledge you have of their situation with regards to COVID. If you don't do that, again, the judge can adjourn the case and you could be looking for a longer wait for a hearing, a possession order. Like I've said before, it does apply to accelerated possession cases. So the landlord must provide a copy of the document explaining what knowledge they have of the tenant's situation with the copy of the claim form. So this is really important. This is slightly different. Accelerated possession, you have to provide that document explaining the tenant's situation with the claim form. Whereas if you're just putting in a claim for possession under normal circumstances, Section 8 or Section 21, and it's not accelerated possession, then you just need to bring that to the court at the day of hearing. So the notice from the court, now this is really interesting. So the court will give a minimum of 21 days notice to both the landlord and the tenant in respect of any listed or relisted hearing. So normally what would have happened, you would have put your application into the court, and then you, for example, will get a letter, and so will the tenant, saying your hearing is set for this date. These new temporary regulations have said the court must give a minimum of 21 days notice. So that means we know that we're already working with a time frame of at least 21 days. The normal rule that a hearing will be listed 8 weeks from the issue of the claim has been disapplied. So we can't work with that 8-week rule anymore, which is something we could have held the court to ransom almost with. This basically indicates the significant delays that the courts are going to be facing, and it just goes to show the impact the pandemic has had on the stay. It's a good piece of knowledge to work forward with, that if you have served notice in 2020, do not expect to get your eviction before 2021. It won't be happening. The courts are too backlogged, and with the reactivation notice required and what is required inside that reactivation notice, many applications to court will be adjourned and moved to a different desk if they're not filled out completely correctly. So it's really important to know what you need to do in the timeframes that you've got to do it in. And I'm just going to come on very quickly to eviction warrants. So this is where we're talking about the Civil Procedure Amendment number 3, which was obviously just before number 4, which we're talking about earlier. Includes transfers of possession to the High Court. Now, normally what would happen is once it's transferred to the High Court sheriff would just go out and execute an eviction, and the tenant wouldn't be informed of that. However, these new Amendment number 3 rules state that a notice of eviction must be delivered to the premises not less than 14 days before the warrant is due to be executed, and this includes High Court sheriffs. So there won't be a position now where the tenant opens the front door and it's their eviction day without any prior knowledge. They will have at least 14 days knowledge of the eviction happening. This is really important to understand because obviously they will have time to get advice or support, maybe from Citizens Advice or the local council. And it is possible still at that stage, when the warrant has been issued, to still stay or set aside the warrant or get an extension to the eviction date. So it's just, you need to be mindful that tenants still have that ability to do that even at that late stage. The notice of eviction, which obviously as landlords you won't need to be too concerned about getting this right, because this will be issued by the court and obviously executed by the bailiffs, but be addressed to all persons against whom the possession order was made and any other occupiers. That's really important, any other occupiers. Be in the form prescribed under Direction 83. Now again, this isn't something landlords specifically will need to adhere to because you can't issue the eviction warrant, but it's key to understand what processes will be happening before your eviction actually takes place. And obviously any flaws in this could hinder your eviction taking place if the landlord's eviction bailiff doesn't adhere to these particular rules correctly. Now the actual notice of eviction must be delivered by inserting it through a sealed transparent envelope. Now this is really key. This is not an A4 envelope with a window in it. This is not a window envelope. This is an A4 transparent envelope, very similar to what you'd put in an A4 binder, those document files. So just those plastic covers that we put into the A4 files, one of those, a clear transparent document folder. Or attaching a copy to the main door, again in this transparent folder. It has to be clearly visible. Now, if you can't put it through the letterbox and you can't attach it to the main door, you must place stakes in the land in places that are clearly visible and attach the notice to the stake in this sealed transparent document holder. Now, this is really, really important because if bailiffs are getting this wrong with regards to how they're actually delivering the eviction notice, it could temporarily hinder the eviction taking place correctly, especially if the tenant goes and gets some form of advice. So that's the end of the webinar for me. If you've got any questions, please do post them, and obviously I will do my best to answer any questions that you have. So I just hope that that was informative in regards to the new process. It is a lot to take in because obviously there's a lot of new regulation that's come in very quickly since we all had lockdown on the 27th of March. But I'm hoping these webinars will help you to understand the process a little bit more. So thank you very much for listening and watching, and I hope that was informative. If there's any webinars you want me to do, please do let me know and I will get those recorded for you. Thank you.